Oh, because of administrative reasons, delay. Hey,
May I be permitted to mention one matter, Lordship?
Other service goals. Another affidavit of service.
Yep, sir.
No, there is already one in the record. Vicky?
This is
No, this is a notice. She has been served. Again, affidavit. What to do?
The appellant was
If somebody after service does not choose to.
Well, I leave it to your lordship. If there is a small delay, I leave it to your lordship. I am not objecting.
There is a delay of 21 days in preparing this appeal. None appears for the private respondent in spite of service.
আমি object করি না।
The Union of India is represented by its learned advocate. So after hearing the learned advocate for the parties and upon perusing the averments made in the application for condonation of delay, this court is of the considered view that the appellant was prevented by sufficient cause for not preparing the appeal within the prescribed period of limitation. In view thereof, the aforesaid delay in preparing the appeal is condoned. The application
Who has
stand
drafted this petition?
allowed. The department is directed to
Without your
formally
senior?
register the instant appeal.
Yes, madam. You drafted without your senior's instruction. He has not checked up.
yes, check.
He checked. Can you justify this is the way of drafting paragraphs? We are allowing, that does not mean that the section 5 is in a proper form.
Pending approval.
You have to indicate a plausible ground.
This is the appeal in the next
Signature. तो बाजे লেখা
This is the appeal in
practically
the
there
next
is
week.
no explanation of it.
Next week.
Dealing with the appeal, misplace the file of original judgment of the case and could not apply for certified copy. This is the matter. Next week, बोलना.
While
The
the
next week
while the stay application has not yet been served, only
is not filed, sir.
oh my lord, my lord, my lord,
Record.
my lord. I'm good.
Serial number 3,
Only your name. এই উপরের নামটা কেটে দাও।
My lord, I have the respondent appellate insurance company.
For the petitioner respondent number 1.
Out of time, out of time.
But I was filing an affidavit in opposition in view of the Supreme Court's judgments on the issue of Section 5, my lord. There is a serious discrepancy in the entire thing, my lord.
Of the Supreme Court that it
My lord, 2023 and 2024. I have not brought it today because I didn't think I'll give it to your lordship.
Pankaj Mittal's judgment.
Yes, yes,
Okay,
yes. That's why. That's the reason.
that the affidavit in opposition has to be filed.
Yes. So I'll be filing an affidavit in opposition.
The judgment does.
I did not carry. I do have it out.
View of the Supreme Court judgment I want to file. I have a right to file. That is what I am asking. Where it is said.
I'll get it. Well, I have the references, but I
No, I am giving you. Show us that there is anything which is said with the judgment.
that's 2020 exactly what fell from your lordship. Yes, yes,
I have come across. I read.
yes. I know your lordship knows. That's the reason I just.
Not. Tell us what is that? It indicate that
That inordinate delay, it cannot be condoned, and I have a right to an opposition so that the adjudication will be made on the basis of opposition and reply.
there's no difficulty. But if the court wants that, what objection you have on this? Whether any materials are with you that this statement is absolutely false.
The delay is unreasonable.
Orally accept your objection when you say that it is not properly explained or in that way. But if you have some material that what he says is factually incorrect, definitely you have a right to file a petition.
Yes, absolutely. If there is factual,
Absolutely. Inaccuracy, then
if
definitely.
there is a factual aberration, we can always file. That's exactly what I propose to do. Aberration, I think that's right.
Okay.
Ah.
So they're not said about the quantum whether
The entire time consumed because of my interdepartmental.
We how he will like one day move the application for condonation, another side will have the same treatment. No difference.
There are certain facts which have not been brought on record also. And what is the urgency, Malad, that has not been stated also. Malad, some facts are not there. I'll bring it to the.
Urgent matter. We are taking a normal detention.
Yes. So there are certain facts which we like to elaborate and put on record.
At the time of moving an application under Section 5 of the Limitation Act, the respondent number
One, Malad, one.
yes, raised for a direction for filing an affidavit. According to him, according to him, certain facts needs to be brought to the court in order to prove that the grounds enumerated in the said applications are factually incorrect. In view of the above, let affidavit in opposition to an application for condonation or delay be filed within a week from date. Reply, if any, shall be filed within 3 days thereafter. The matter will be listed immediately upon expiration of period for exchange of affidavits.
Grateful, madam.
On behalf of respondent number 2 and 3, I also file a.
I have then the respondent number 1 and 2. Respondent number 1 to 3.
serial number 4.
Well, I'm for the appellee. This matter, my lord. Honorable Chief Justice, Honorable Chief Justice, sitting with Mr. Honorable Justice Bhattacharya, has already passed 2 orders. And in fact, my lord,
That my brother knows much better.
my lord, there is, my lord, the point is involved that in a sale, my lord, auction sale, when the purchaser purchases a property, he deposits the money because at the very first instance, he has to deposit the earnest money and certain deposits, 25%. And thereafter, he has to pay the balance monies. Up to 90 days, that time is there. And if not paid, then bank what did entire money forfeit. And there is now a judgment, Sanmuga value. The Central Bank of India initially unreported judgment, now it is reported. I have just brought the judgment. There says that no, according to the rule 9345 of the security interest rules, you can at best keep with you the 25% monies. Return the balance monies. Now, my lord, that is a situation where the Honorable Division Bench passed the order and invited the bank to say something against that. The bank on the next occasion could not say anything. On that score, my lord, there was a possibility of settlement. And we came forward together that, okay, whatever money has been deposited and we will pay the balance money. But the bank says, okay, very well, I have the letters. You get a specific order from them. That is the situation today. Well, I will show the bank.
The settlement has failed.
Settlement has not failed. They are saying, bank says, a specific order requires, because if you want to pay the balance 30% only.
Where is the learned advocate?
But there are letters. I'm showing to you.
Where is Mr. Om Narayan Rai? Where is Mr. P.K. Ray? Where is
Lord,
Mr. E. Bellal?
Possibly, my lord, they are not, they possibly will not oppose.
I have to give a notice to them.
I will give again. Then I will
Give a notice to them.
certainly, my lord.
The matter
But in the meantime, will your lordship?
matter it would remain pending here.
Very well,
Give a notice and come back.
very well. I will give them. What is the date, my lord? Next date, my lord.
What is the next date? It is simply not today, give a notice to them.
Right.
Get. I was supposed to take a passage and quarter. I guess it is like so good. With your bank card, I think instruction.
Time for the respondent, state respondent.
Out of time, but we. No. With time. Appellant नहीं तो. Not today. Not today, then appellant.
After the petition, my lord.
One for the state respondent.
Not today.
Not today.
Because there was a. No.
My lord, petitioner running a my lord, প্রধানমন্ত্রী জন ঔষধি কেন্দ্র।
Running,
Yes, I'm running my lord.
he is running Pradhan Mantri.
At a shop of my lord, under the প্রধানমন্ত্রী জন।
The shop
Yes.
allotted to you under that particular policy or Yojana.
Yes, yes.
You say you are running that Yojana. I was really shocked.
My lord, I'm running a shop.
Say that. Petitioner is running a Pradhan Mantri that Yojana. I was really shocked that the government is supposed to take care of that.
My lord, I am for the private respondent on 13, 14 and 15.
My lord, according to the policy of this scheme, there is a my lord, distance policy. Distance of minimum 1 kilometer to be maintained between two kendras.
What is this Kendros?
My lord, this kendras means
Purpose
this
of
shop,
this-
these shops.
Oh, Jana Aushadhi Kendra.
Jana Aushadhi Kendra. Now, my lord, if your lordship kindly come to page 79. Page 79, there is a distance policy because, my lord, the scheme of this entire policy is that to provide a low-cost medicine,
That's a generic medicine.
as well as to create, my lord, the entrepreneurship among the local villagers. Or also, my lord, I can say that
Entrepreneurship
job
involves-
creation of employment or job employment, my lord, this kind of, my lord. So, my lord, so as per the policy, they can, my lord, there is a distance policy that within 1 kilometer, my lord,
1.5 kilometer.
no, my lord, 1.5 kilometer, 1.5 kilometer in a district having population less than 10 lakhs.
Okay.
And the Delhi, Mumbai, Kolkata, Chennai, Bangalore, and Hyderabad, Ahmedabad, and district having population equal to or more than 10 lakhs, 1 kilometer. Now, this is in, my lord, in the district of Howrah.
Okay.
Now, my lord, my only contention that the respondent number 13 was allotted with a shop within 1 kilometer. So, my lord, the learned single judge, based only on the basis of a submission made by my learned friend, that this is not within 1 kilometer, it is 1.1 kilometer. Rejected my writ petition. My only prayer before your lordship, my lord, let a report be called from the union.
We will make a roving inquiry as an appellate court.
No, my lord, I am not asking for
Then why-
my lord,
why
only
you
a
say-
report from.
If the court has said that it is actually exactly 1.1 kilometer, so it's really more than 1 kilometer.
My lord, the course, my lord,
So in that event, why we will enter into the roving inquiry or make a roving inquiry for that as an appellate court?
my lord,
You had the opportunity to ask for a report. You had an opportunity to submit the documents that you lost.
but my lord, the
As
court
an
comes,
appellate court, what you
my
will
lord, the
do?
court come to a conclusion that the distance between these two kendros is
There
1.1
must be some
kilometer.
material on the
Nothing.
record.
Nothing. Lordship, kindly come to the impugned order, my lord. Only on the basis of submission.
I do not know in the writ proceeding, was there anything which they have disclosed?
Nothing. Only on the
1
basis of,
kilometer.
only on the basis of formal submission, my lord.
Can't do.
Well, kindly come to the impugned order once. Only on the basis, that is the reason, Malad, I'm only praying. Let a report from the authority comes. If it is said that this is beyond 1 kilometer, I have no case. But when there is a particular policy, Malad, and this policy restricts this 1 kilometer,
You are having your own Jan Aushadhi Kendra
yes,
in
but
the same area.
in the same area, but Malad, this is a local, it's a village area, and if this Kendras will come, Malad, within a close vicinity, Malad, my
But you are talking about the village, you are talking about the Howrah, which is
Malad, Howrah district, Malad,
big district.
Malad, Howrah district, Malad, the Howrah district.
No, it's a big, I would say the town or a city, I can't, now it is a city.
Howrah city, Malad, but here, Malad, the thing is, Malad, it is within a district having 10 lakh population. Now, Howrah district, Malad, I think, Malad, the population
More than a crore.
more than a crore. Now, Malad, my Kendra, I am running a Kendra in a village, namely Sakrai.
Sakrai is no longer a village.
No, Malad, it's
It's a full-fledged developed town.
no, Malad, it's no.
Sakrai,
Malad, I am residing there. It's not town, but there is some business hubs are there.
like you, a person is residing that shows it's a town. And a person like you cannot, it's not expected to live in a village.
It's not, I can't say that,
You are
but it's a panchayat area, Malad. It's panchayat area. It's panchayat area. So, Malad, my only contention,
What is the population of the peoples in Sakrai? More
What,
than 10 lakhs.
so far as Malad, the Shakrail assembly is concerned, Malad, I think it's around 5 to 6 lakhs.
More than that.
Yes, because 5 to 6 lakhs, Malad. In Shakrail assembly.
You can go by that assembly area.
So, Malad, my only thing, only to prayer, Malad. If it is within 1 kilometer, I have a case. If it is beyond 1 kilometer, I don't have any case. So, Malad, I'm only asking, Malad, praying before your lordship, kindly give a direction upon Malad, the authority to submit a report on a spot inspection. Because I tell you, lordship, when I applied, my initial application was rejected on the basis of there is no viability in the market. There was a market survey. But in this case, the stand of the authority is that we need not require any market survey and will grant the license. Malad, the question of sustainability of a person is also there, because if it is in close vicinity, it can be done, Malad, because it's all are the generic medicine. It's not that any shop room like 2 or 3 shop room stand in close vicinity. So, Malad, let a report, Malad, come from the authority. Only this thing, Malad.
Hello, the learned
Malad, page 2, paragraph 3. Kindly consider.
Where is this state or a union?
Unit have some.
may I satisfy lordship? Learned single judge may not have reflected a document which I praised before her lordship. Actually, kindly come to page 13. The writ and appeal suffers from the vices of suppressive very suggestive policy. I am reading out page 13, subparagraph Q. The petitioner in such a court made a complaint before the marketing officer of PMBI, inter alia stating all such facts. Despite having a PMBJ in Chapatala area, the private respondent number private respondent is going to open a new PMGK. After making such complaint, various telephone calls, both of the representatives of the marketing officer visited the PMBJK of the petitioner and stated that existing PMBJ Kendra of the petitioner is not within distance of 1 kilometer from the newly approved Kendra of the respondent number 13. The marketing officer making such fall averment asks the petitioner to sign on a document which states that the distance between the newly approved Kendra is not within distance. What document was signed? I'm placing, which I also placed before. It is signed by the appellant himself. Actor. On the basis of this document, actually on the basis of their complaint, inquiry was held, then it is found this. And next page is, I took a measurement, actually on air distance is 1.03 and road distance is 1.1. Furthermore, appellant is stopped by his own conduct. Why? Kindly have a look into the present guideline. That guideline has already been amended. Kindly come to page 93. There is an admission. 93. Subparagraph E, I. Distance of minimum, kindly take note, minimum 1 kilometer to be maintained. If it is 1 kilometer, then entitled. Between two Kendra, while approving new Kendra in all districts throughout the country, there is no averment of any population. Now, my lord, kindly come to their admission, page 103. They have annex. Top of the 103. A sketch. It is 1 kilometer. If it is 0.9 kilometer, not entitled. If it is 1 kilometer, there is stop. Is entitled. They are himself admitting it is 1 kilometer. Furthermore, as per their complaint, inquiry was held by the concerned authority. They found it is 1.03. My lord, this stop 1 kilometer. Champatala and Hawapota. If it is 1 kilometer, my client is entitled. If it is 0.09, my client is not entitled. They are stopped by their own conduct. They have already admitted it is 1 kilometer. Minimum distance, not within, minimum distance.
It must be, if it is 1 kilometer, it comes.
If it is 1 kilometer, I'm entitled.
Less than 1, then
Mine.
it will.
If it is 0.09,
According to
0.9,
their own case
I'm
is
not
1
entitled.
kilometer. Keep it.
That document has been suppressed before the court.
Was it supplied to them?
Yes, I have already
Now
supplied.
that
At that point of time, obviously,
So,
yes,
the council,
I placed before the learned single judge considered it, may not have reflected in the order about this document.
no, it is,
in
First
paragraph
page
three-
is-
in paragraph 3, page 2. In paragraph 3, page 2.
what more? What more? Nothing.
Only
Your
thing,
own document, sorry, your own document talks about this.
yes. Grateful man.
Your client has not instructed properly.
This document everywhere statement
Was given to you.
yes.
Serial number 7.
My lord, on behalf. My lord, on behalf of Mr. Jayanto Shamanto, who is on his legs before court number 37, my lord, I'm praying for a short passover. Mr. Jayanto Shamanto, learned advocate.
Going to someone to, his name is not appearing.
My lord, I've been instructed. I've been instructed by the. My lord,
Lordship, last
for the
occasion,
respondent, my lord.
I'm appealing.
Last officer,
Respondent is steep or what?
My lord, I'm.
Don't know.
No, my lord.
Then why you have come?
Last occasion, Lordship directed me to file the report on behalf of the block development officer, Lordship. May I file my report, Lordship?
That matter, my lord, regarding tender, my lord. I'm the lowest bidder, and my lord, I was kicked out. Intentionally, by
You say that you were prevented by somebody else,
Somebody
the
else, yes.
Panchayat Pradhan, and
Panchayat Pradhan.
everybody
And then
prevented you
they
from
are
entering into the,
hooligans.
and then,
I have made representation to the complaint before the police as well as Panchayat Pradhan video.
My lord, may I have your lordship's leave to take further instructions, my lord?
I need a copy.
Lordship, may I provide a copy to him?
Okay.
দিলাম তো
Copy down.
আমি দিয়ে দেবো
can you supply me the date of this, the Pradhan has lodged a complaint against him?
at no,
You have said?
no, Lordship.
You
That
have
is written,
said,
dear Lordship, but
that
copy is
Pradhan
not
lodged a complaint? Where is the
Lordship,
copy of
copy is
that?
not supplied, man.
Why? He's a block development officer. Is he not supposed to give all the documents? You have given all the statutory documents which are there for the purpose of conducting the tender. But the real question is not how you conducted the tender. The real question is whether he was prevented. And if he failed to deposit, whether it has to be given to L2.
The first line, my lord, they have written, my lord, the petitioner wanted to collect work order from the block development office, my lord.
He says that you lost the complaint undated letter,
Undated. Sure.
but where is the complaint of the
That
Pradhan?
is not supplied to us.
Where is the complaint of the Pradhan? You say that the Pradhan received or lost the complaint for you, to you. Where is that letter?
Lordship, that is mentioned here also, but they have
No.
not supplied it.
My lord, may I,
Yes, original
may
section
I permit to mention item number?
beginning in the first half. You want to file a appeal?
Appeal I could not file because some difficulties arises in the computer section for scanning is not defective, or rather properly not working. That's why you couldn't file it on online, my lord. That's why I'm praying
For
for
the state?
the Union of India, my lord.
Oh, that's means
State, my lord. Leave may be given, my lord, to file physically, my lord. Otherwise, my lord,
আগে grant করেছি তো। Appellate or original side?
original side, my lord.
Grant leave. The physical form.
I'm grateful, my lord.
My lord, I appear for the appellant, my lord. I'm for the hospital, my lord. On the last occasion, my lord was kind enough to grant us an extension of 1 week, my lord, to make the payment. Your lordship will recall. Your lordship, we have not been able to make the payment, my lord. I'll leave it to your lordships, my lord. We have not been able to make the.
Can be done there. You same thing you submitted on the last occasion also November 13 that you are hospitalized. The order reveals that the learned advocate for the appellant slash hospital submitted that is a great financial distress and have been a substantial borrowing. What can be done?
My lord, the distress continues, my lord, on the last
What can be
occasion.
done, sir?
My lord, with great embarrassment, my lord, I have again received a letter, your lordship, from my client, your lord.
The court was very, I would say, very lenient for you, granted you some time, twice, thrice, every time they gave you. If you cannot manage, then we are helpless.
My lord, your lordships have been very kind, my lord. Your lordship.
But how long? There must be elasticity to reach at the level of.
I totally understand, my lord.
Can be done, sir.
My lord,
Not extend further.
my lord, just one indulgence, my lord. I've received a letter, my lord, from the client saying that there have been some donations that they are to receive, my lord. Communications with the External Affairs Ministry is still going on, my lord. 56 lakh is to hit their bank account. Now, my lord, if your lordship just keeps the matter after vacation, my lord, this 25 lakhs can be, my lord, remitted.
We can't extend the time. Sorry, can't.
My lord, we have letter communications from the client, my lord.
Maybe the client, if he has suffered a loss or he has suffered a decree, then what can be done?
My lord, 25 lakhs can be paid, my lord,
No,
by the end of December, my lord.
no, sir. That was given to you.
I totally appreciate, my lord, but
What can be done?
my lord, we have letter communication from the donor, my lord.
Whatever.
My lord, this can be paid off, my lord. The 25 lakhs can be paid off.
It's up to them. You approach them. If they agree, then it's all right. Otherwise,
Your lordship this is the 6th time they are saying
we
this.
have seen that the conduct is so bad.
Before vacation, they have
I
to
have
pay
seen
20
on the
lakh
order.
rupees.
I think the other division bench was very
Yes, your lordship.
kind enough to extend the time, considering that they are the hospitals.
My lord, we are a charitable hospital, my lord,
what can be
depending
done?
on donation.
No, your purpose and object of establishing the hospital is very good,
Yes,
very pious, very noble. But at least once you have suffered, then you should.
Even we also have compromised from 1 crore 10 lakhs to 50 lakhs. We have compromised.
My lord, they are very
What more
well-to-do
can
organization.
they give?
Lord,
What more that?
my lord, for last chance may be given, my lord. I'll leave it to your lordship, my lord. Last chance, my lord.
No,
আজকে পর্যন্ত
Hey,
4th December ছিল আমরা
where is the order of 4th December?
It has not been uploaded yet. It has not been
Perhaps
uploaded
not
yet.
been uploaded, my lord.
The time was extended.
Up till my lord, yesterday.
12th
12th.
12th and
Yes.
today we direct.
Yes, my lord. My lord, my lord, I'll only submit, my lord, that there are certain donations that are to come, my lord. My lord, 27th.
If the donor is has come up for some kind of a respite, then he should show the alacrity. Why he will?
My lord, I'll, if I may, my lord, share the letter communication, my lord, where they have said that they are donating, my lord, 56 lakhs. My lord, may keep it after vacation, my lord. By then, my lord, 25 lakhs can be paid off, my lord.
We will not extend the time. See, we can adjourn the matter, but we can't.
In that case, my lord, may simply adjourn the matter, my lord. In the meanwhile, my lord, we can
Whatever you
speak to the respondent, my
Your
lord.
lordship, on the last occasion, they have told the court that they are going to give it on the till January. They have taken time. Now they are saying that on the end of this December they are going to pay.
they are not going to extend it, sir.
My lord, may simply, my lord, adjourn the matter and fix it, my lord, to be heard on merits, my lord, and my lord,
What hard on
my lord, the appeal,
Matter has been
the
heard
appeal
on the
really, my
merits.
lord, is a challenge to the conciliation proceedings, my lord, under the MSA.
on the prayer of the appellant, the matter is adjourned. Till the Christmas vacation.
Grateful, my lord. Grateful.
Much obliged.
I'm for the respondent SCC, my lord. There is a delay of 657 days delay, man, in preferring appeal.
My lord, in this matter, Mrs. Dasde is appearing. There has been bereavement. Mrs. Dasde.
Smita Dasde is appearing
Her
for the.
mother expired the day before yesterday, my lord.
Is submitted on behalf of the appellant that Ms. Dasde.
Smita Dasde. Smita Dasde.
Dasde, who is appearing for the appellant, has a bereavement in her family and unable to attend the court. In view of the above, let the matter be listed after the Christmas vacation.
Grateful, my lord.
There is another issue connected with this appeal. Payment.
He has
I am not,
he has
I am
lost
not-
mother.
I am not going into that issue. Minor Mr. Bhattacharya knows. In connection with the appeal, there is another issue for payment to the lawyer. That's what? Payment to the Ministry of Law and Justice lawyers and income tax lawyers. The other issue which was thrust by them. So let this also, because it was on my submission, the
Payment
other
is not made.
payment is being made from time to time. That is that recorded in the order.
And
The last order says the rest of the payment.
charged on what? Whatever the payment is received is charged on what? In a pro rata basis or
This payment is for legal fees to the lawyers.
you could not understand what I mean.
Pro rata. No pro rata.
With the specific choices.
It's not blood. No, now I can assure your lordships there is no specific choices. On my persuasion, that is recorded in the orders. The law secretary released certain funds before the puja vacation, and part payments are made to the Ministry of Law and Justice lawyers to all. And the other aspect is about the income tax payment to the income tax lawyers. The income tax department has now gone to the income tax department from Ministry of Law and Justice from April to 2023. Therefore, they shall directly pay to the income tax lawyers. And the last order is that the division bench granted leave to the income tax lawyers to make application. No application has been made as. So let this also be appear after vacation.
Which matter?
This one matter.
This
Which item number?
this number, my lord, this is item number 3.
Both are adjourned.
Yes.
Very good.
Grateful, my lord.
Lord, I beg to appear on your responding. চারটাই তো আমার কাছে আছে, পাঁচটা তো আমার নয়।
My lord, I am appearing for the appellant due to sudden illness of the learned chartered accountant. He was out of station for his heart surgery, so 3 months delay in filing the appeal. Chartered accountant appeared before the ITAT and he handed over the paper to me in 3 months delay for due to heart surgery in South Indian hospital. So kindly condone the delay and allow the prayer. Both 4 and 5 same matter, my lord.
কোর্টটাই তো 5 কে আছে। ফাইভটা সার্ভিস করেছেন ডিপার্টমেন্টে, জুডিশিয়ারি ফাইভটা।
Service করেছি, service দিন এখন hands up.
এফডিবি সার্ভিস আছে।
দিয়ে দিচ্ছি।
Order ছিল না? There is no order.
দেখো তো এটা সার্টিফিকেট মেল।
Which simple adjournment. Simple adjournment হতে পারে।
এটা তো পেয়েছি রে বাবা, এটা নয় এটা। আমি তো কাউকে সার্চ করছিলাম, পাইনি।
Yes, what do you say?
ভালো।
Hey.
There's a delay of 105 days in preferring this appeal. After going through the averments made in this application, this court finds that the made in paragraph 3 and 4 of the application for condonation of delay, this court finds that the delay was due to the illness of the chartered accountant who conducted the proceedings on behalf of the appellant assessee before the learned tribunal. After hearing the learned advocates for the respective parties, this court is of the considered view that the appellant was prevented by sufficient cause for not preferring the appeal within the prescribed period of limitation. The delay in filing the appeal is condoned. The application stands allowed. The department is directed to formally register the instrument.
আমাকে এঙ্গেজমেন্টই করেনি।
Let the appeal be listed under the heading for admission in the next week.
কাকে দিই?
Much obliged and grateful, my lord.
Next one.
मतलब आइटम नंबर 5 मतलब
Item number 5 same matter, my lord.
Okay, that you are moving.
Apologizing, my lord.
Delay is also same.
Same, same.
Two different assessments.
Yes.
Same order. একবার ডিলেট এটা পিরিয়ডটা দেখে নেবেন। Yes, 5.
Much obliged, my lord.
Yes, take.
I'm appearing for the appellant, my lord. My lord, in this matter, the service has been effected yesterday only. The service has been effected yesterday only. Earlier, I had sent the
Today, has the service report come?
yes, my lord.
Has come
It is
to you?
delivered, my lord. May I file, my lord?
Not today.
My lords, I am for the respondent. My lords, in this matter, there is a delay of 165 days.
Where is the appellant?
I'm for the appellant.
Why the delay has occurred?
My lord, the departmental formalities.
Departmental procedural hassles.
Yes, my lord.
My lord, the delay has not been sufficiently explained, my lord.
What they say that they have to move the different authorities for the purpose of approval and waiting. That
My lord, the same approval, if you kindly come to their petition, my lord, it's page 3. The approval was page 4, Your Honor, my lord. The approval was taken from DGIT investigation, which is the top officer of the central wing, as back at July 2024. And even after that, the appeal was filed with condonation in the month of November.
but the intimation was not given on time because the intimation has to be routed through the several authorities. They have said in paragraph 13, 13 and 15.
My lord, I'm not even on the merits. They don't have any.
My lord, I have a very good case, my lord.
Very good.
I have a good case.
There is a delay of 165 days in preferring the instant appeal. The learned advocate appealing for the respondent vehemently opposes the prayer for condonation of delay. However, after going through the averments made in the application for condonation of delay, this court finds that it has been stated in details the manner in which the approval from the competent authority was obtained prior to preferring this appeal. This court finds that the delay has been sufficiently explained. We exercise our discretion and condone the delay in preferring the appeal. The application stands allowed. The department is directed to formally register the instant appeal. List this matter under the heading for admission in the next week.
I'm appealing for the appellant, my lord. My lord, in this matter, I am led by Mrs. Das Day. The service has been effected, my lord.
Anyhow, we are not accepting same order. Bereavement in the family of Yagir order Kurishina. Item number?
Item number, the earlier one, my lord.
C3.
6.
Ms. Dasti, the adjournment was given after
And item number 3, my lord.
3.
same order. Yes.
I'm appearing on behalf of respondent.
But here delay is about 111 days.
My lord,
Wow.
this matter relates below monetary limit they themselves stated in para 6, page 4. They have challenged on exceptional circular. The circular came in March to
That is the merit. Condonation, tell us.
it is afterthought, my lord. Merits on the
Condonation is
point, my lord.
afterthought.
Because tribunal order passed on 14 February 2024. They have challenged a circular 15 March 2024. It ought to have filed within July 24, but it was filed in November, and matter relates to below monetary limit that they themselves.
That is on merit, whether the appeal would be entertained or not. Condonation, you have to consider.
Then,
first.
my lord, I'll file opposition.
Yes.
There is a delay of 111 days in preferring the instant appeal. After hearing the learned advocates for the respective parties and upon perusing the amendments made in the application for condonation of delay, this court finds that the delay in preferring the appeal has been sufficiently explained in the said application. The delay in preparing the appeal is condoned. The application stands allowed. Department is directed to formally register the instant appeal. List this matter under the heading for admission in the next week.
Beg to appear on the appeal, my lord. Here delays, my lord, 430.
You people always use the word beg.
My lord.
Yes. You have a right to appear.
Mine.
Then again delay.
But here delays, my lord, 432.
Then he must get an opportunity.
Yes, my
you
lord.
serve the copy.
My lord, service complete.
Go on.
Item deliver on 9/12. But here, my lord, delays occurred because, my lord, the my lord, tribunal of my lord, Bombay passed the order. Thereafter, my lord, the one judgment passed by the Honorable Supreme Court that where the assessing officer, my lord, passed the order, the appeal should be filed on that High Court. In that occasion, my lord, some delay has occurred.
Whatever, but they have a right to be.
Yes, my lord.
Now, despite service, there is no representation on behalf of the.
I'm done.
Wait, please, Your Lordship. My lord, I'm appearing for the plaintiff in the appellant in the matter. My lord, there's a delay of 284 days. We have served, my lord, Mr. Bhattacharya as appearing. May we file the affidavit of service, my lords?
ব্রিফটা বলুন ওখানে আছে ব্যাগের মধ্যে ব্রিফটা আছে মোটা
But from October 18, 2023, my lord, 120 days come to an end on February 15, 2024, my lord. There's a delay of 284 days, my lord.
Lord, on the main matter, may I only indicate this? Lord, may I very humbly submit for the main matter, my Lord?
What your client does,
My Lord,
what your client does.
she invests in shares. Housewife invests in shares, but the main matter, my Lord, is
Husband does.
what do you do? Business. But I have to take instruction what the husband does. Business. What business? My Lord, may I only indicate? Because in the main matter, my Lord,
Business or what?
we have to take instructions, my Lord. I am not aware. Lord, may I only indicate this?
Please take instruction first.
Lord, kindly grant us 2 minutes. Lord, in the meantime, may I submit this? Lord, on the main merits, Lord, kindly permit me. Lord, may I?
If I cannot take up the matter, then why you are exhausting your energy?
I'm so sorry, my Lord. I understand. In fact, that is the reason, Lord, I was praying, not for any other reason, because
No, that is the reason I asked. that
Lordship,
what he does.
I got the hint, Lord. In fact, Lord, the main matter is there's a judgment of
We don't want to enter into
Lordship.
এইটা তো আমাদের পিটিশন, এটা পিটিশন দুষ্টুমি করবে, এটা তোমার পিটিশন দুষ্টুমি করবে, দেখুন এই একটাই কপি আছে, আমি দেখেছি স্ট্যাটাস ফলো নি কেন, নাও নি কেন, এসে স্টার্টিং এ এক্সাম এখানে লেখা আছে, এটা দেখি তাতে তো প্রিভিয়াস আছে, জায়গা মতো রাখো।
a long-term investor in shares, my Lord. He invests in shares. That's my instruction.
The He's the income tax lawyer.
The income tax lawyer? No, my lord. My lord, in case of a difficulty, my lord, your lordship may place it in January, my lord, before the honorable lord.
The names are very familiar.
I understand that, my lord. I thought so, my lord.
One IC Bag happened to be my client when I was on that side.
Lordship.
And then I appeared in many matters. I do not know the name of the lady.
My lord.
I could recollect the name of the husband. But he was in Amartalla Lane. I just wanted to know whether that is the person having any connection with Amartalla.
My instruction, sir, my lord, is not a lawyer.
What is the name of his father?
I think that will be better.
Because I have lost touch. So in the meantime,
Indeed,
they have
but-
shifted their office to some other place. I do not know.
Lordship.
ক্লিপটা লাগিয়ে রাখো ক্লিপটা কোথায়
My lord, let Deepchand back. Let Deepchand back.
Father name was Bhairudan Bag. That's it.
Then different individuals.
Different man.
My lord.
It will be not today. It is.
Lordship. My lord.
Yes, next.
Lord,
I see that.
delay of 13 days.
Right.
Service complete, my lord. Affidavit of service is there.
To appear for the special director of enforcement.
No.
Who appears?
Respondent actually. Directorate of enforcement. Like perhaps Mr. Bhonjo and
Directorate of enforcement.
Orijit Chakraborty appears.
Yes, Mr. Chakraborty is appearing. Orijit Chakraborty. Hey. কে appear করে director of enforcement? Director of enforcement. Orijit Chakraborty.
Give us the affidavit of service. तीन तारीख के दिन third of December. What is that? What is
Affidavit of service filed in court today is taken on record. It reveals from the said affidavit that the item was delivered to the respondent on December 3, 2024. In spite of service, none appear.
One days delay. 141 days.
Malan, I'm not opposing, my lord. What I'm on the last occasion, my lord, your lordship directed my lord to file the Okalatnama, my lord. Today they are filing, my lord. Today they are filing, my lord.
You are filing or somebody else is
No, no,
filing?
the competent person is coming, my lord. He is filing, my lord.
It is the company who is filing.
ভোগালাতমা আগের দিন হয়নি বলে এখন আজকে today filing.
Well, let the delay be condoned and let it appear.
Can you file in course of this day?
Yes, my lord.
Awesome.
Lord, in this matter, your lordship was pleased to grant me leave to correct the cost title, my lord. The Allahabad Bank now merged with the Indian Bank. My lord, I couldn't get it, my lord, corrected because the order was not in the website, my lord. That's why the
It came yesterday. Yes, I got the order.
my lord,
Order came yesterday.
yesterday the order has come, my lord.
Let them correct
My
the
lord,
cost title.
Advocate was there, my lord. Department didn't allow him to, my lord, correct, my lord.
Not today, carry out. Today
But in
itself.
the meantime, I'll file Bokalatnama. Let it appear.
I think we are not recording any order, carry out.
My lord.
Matter will come. Matter will come.
My lord, matter will appear.
So, देखो, it is submitted by the council for the app.
Item number 15, service is not complete. Kindly give us 2 weeks time to complete the service.
The service is not complete. Let the matter be listed in the next week.
Well, after 2 weeks.
Your Lordship, in item number 16, I'm just 16 and 17 in both. I'm appearing on behalf of the respondent, Your Lordship. We have just received the copy day before yesterday. So we have to take the instruction from our client also.
What is this application?
It's their application, Your Lordship.
But this is my lord. Intra-court appeal, my lord, challenging the order of the my lord learned single judge, where the my lord assessment year 2013-14.
Single bench.
Yes.
The application for stay.
Yes, my lord. Two application, my lord, one condonation of delay and my lord stay.
Okay, so what's the application for condonation?
Yes, my lord. There is a delay of
78 days.
my lord, here, my lord, may I submit one thing, my lord? My lord, the matter relates to my lord assessment year 13-14, 14-15. The my lord learned single judge, my lord, decided that the notice issued, my lord, is time barred. Thereafter, my lord, the matter also reached to the my lord, Supreme Court. And my lord, the Supreme Court was pleased to hold that, my lord, the notice issued in my lord 12-13, 13-14, my lord, within the my lord, stipulated time, my lord, in that my lord, situation, my lord, delay has been occurred.
So, what the Supreme Court has said.
My lord, Supreme Court judgment, single bench judgment. The Supreme Court, my lord, here, my lord, the notice issued, my lord, for the relevant assessment year after the time for framing the notice, thereafter notice has been issued, taking the benefit of taking the benefit of the taxation amendment laws that was enacted in the COVID time. It has extended the time for issuing the notice. The alternate single judge of the view that the Taxation Amendment Act cannot take shelter of the Income Tax Act, and the Income Tax Act is a self-contained act, but the revenue cannot take the benefit of the taxation amendment laws. Then on that perception, the Honorable Single Judge dismisses several matters, and your Lordship kindly see, I have only one copy because that has been used also, the single judge today, 2 copies. In this matter, the Honorable Supreme Court on 3rd October 2024 says that the revenue can take the benefit of taxation amendment laws. May I please? Only one copy I have today.
On a delay, first you cross the hurdle. What do you say?
Your Lordship, we have just received day before yesterday, then we have to just contact our client also, whether he is ready to deal with the matter or not.
Not today.
Much earlier. 16, 17, Your Lordship, both matter. Much earlier. 13.
I beg to appear for the respondents.
I am appearing on behalf of the appellant writ petitioner. Lord, we are appearing on behalf of the appellant writ petitioner. Lord, kindly have a look at my stay application, page 68. Lord, page 68 of my stay application. This is the document by dint of which the tenancy was given. It has been the one of the clause. Got it, 68. Second, first paragraph, after first paragraph, the tenancy will be on the month-to-month basis, terminable by the 15 days notice, either by the side on the expiry with the end of the English calendar month. I have, submitted a letter appearing at page 73. Only, I will place the relevant portion, page 74. This is a letter dated, 14th of June, 1983. I have surrendered the tenancy by dint of the letter. Kindly have a look at penultimate paragraph appearing at page 74. Under the circumstances and after the meeting of the board of the directors of the company and which was held on the 11th of June 1983, it was unanimously decided that since your department and even after the repeated request and the discussions as they failed to comply with the rules and the regulation and to provide us with the calculation and the based on which such outstanding dues were arrived at, which is completely contrary to the rate of the increase of the actual rent, that is 50% of the actual rent, we are left with no other alternate option other to hand over and the surrender the leasehold above the such and such mentioned petition, such and such along with the department. Then you are therefore requested to terminate the lease agreement between us and the provide us with the exact amount that is due and the payable in respect of the actual rent outstanding from the June 1982 to pay 1983, an arrear of the rent of the 25th of June 1981 to the 31st of May 1982, in accordance with the increase such and such. So, my lord, in consonance with the clause which I have shown, this notice has been given, and kindly take my lord trouble to have a look at the next two documents, that page 67 and the 68. I am having the original, my lord. If your lordship pleases, I will produce the original. This document has been received by them, and this has been sent through registered post with AD. So the issue 76, my lord. 76 and 77. So the issue is, initially thereafter, my lord, in the year of 1994, a proceeding has been drawn under section 5. I have questioned whether if I am not in the unauthorized occupation, if I am not in occupation, the question arises whether a proceeding can be drawn under section 5 of the Act of 1971 or not. On the day when the, my lord, in the year of 1994, the proceeding was drawn, the notice was served. The notice, maybe. My lord, the notice was served. My lord, kindly have a look at the said document at page 83, my lord. 83. Kindly take trouble to have a look at.
Section 5 notice.
No, my lord. The proceeding has been drawn up, and on the basis of which, yes, only
Opinion formed by the state officer under section 4, and then the notice.
then, my lord, what I intend to, my lord, draw your lordship's attention, kindly
Read it.
my lord, Messrs. Armanjo such and such, Srimati Monjushi such and such designation of the junior inspector have served this notice under the section 4 and the 7 of the Public Premises Eviction of the Unauthorized Occupants Act of 1971 to my company, 19th of April 1994 at about 2:30 p.m. Then, my lord, kindly see, my lord, if it is, my lord, bearing such an image, my lord, kindly see, my lord, in presence of two persons' name has been there, and this notice has been notified in my subsequent, my lord, the address that has been 5 Jawaharlal Nehru Road. So when the, my lord, the proceeding has been drawn, first notice was given 5 Jawaharlal Nehru Road. So they are aware about the fact that this is my address. There is no discrepancy, nothing else. Then thereafter, my lord, kindly take trouble to, my lord, the subsequent the order which has been passed. Thereafter, that is page 90.
What are you assailing?
I am assailing the impugned order passed by the trial court.
Impugned order passed by the trial court means single bench.
Single bench.
What? What for you approach the single bench?
I have approached because the order passed by the estate officer under section 5.
Can you, if there is a provision for an appeal under section 9?
Yes,
So,
I can.
so
I can file a writ petition, my lord. This,
you can file a writ petition.
yes, this point has been taken by the honorable single bench, and that has been, my lord, reflected in the, my lord, the impugned order. I will lordship's, my lord, view that I want to satisfy your lordship in that score itself, that whether in what are the circumstances.
The writ court refuses to entertain the writ petition because there is already a efficacious remedy elsewhere.
My lord, with humility, my lord, this is not the finding of the trial court. This is not the finding of the single bench.
What is the finding?
Single bench found that on the ground on the basis of which I have challenged the propriety of the order passed by the estate officer dated 27th of March 2006. That is neither perverse nor suffers from, my lord, the procedural impropriety for violating the natural justice, but which is, my lord, evident from the record that this is, my lord, the suffers from, my lord, the violation of the natural justice, as well as this is a clear case of perversity, only because of the two reasons. If your lordship will see, my lord, your lordship would be, my lord, the astonished to see that how the estate officer has ignored certain evidence where it has been categorically stated that I am not in occupation of the subject premises. Only, my lord, I am drawing your lordship's attention. See, my lord, kindly document. That is, my lord, page 95. Page 95, my lord. Kindly see page 95 once.
Mr. Dotto, what was the point raised by you before the learned single bench?
The point raised by the
And
learned.
come to internal page 2 of the order,
My
your
lord.
submission.
My lord.
Internal page 2 of the impugned order, your submission made before.
My lord, if your lordship permits me to place the, my lord, the impugned order, I will say.
We are at the impugned order, page
Yes,
2 of the impugned order.
Yes, my lord. Kindly.
Your submissions have been recorded there.
Yes.
And the decisions,
And the observation.
And the decisions which have been relied by you has been recorded. So we are asking you, what was the submission made by you before the learned single judge?
Yes, my lord. The same argument, my lord, that has been put forth.
That was with regard to the maintainability of a writ petition in view of existence of alternative efficacious remedy.
My lord, kindly, my lord,
that was the point raised by you.
My lord, I have
single judge has observed principles of natural justice, no violation, order cannot be said to be perverse. On that line, this was the argument. And you invited these observations of the learned single judge in a writ petition.
My lord, only because, if your lordship, my lord, kindly consider, your lordship is absolutely correct. But the, my lord, since I have invited, prior to that I have satisfied the honorable single bench, that, my lord, what are the circumstances when, although there is an alternative remedy is there, the writ petition can be entertained. I have already, my lord, placed one decisions to that effect. Apart from this, my lord, there are, my lord, the division bench is also there, passed by Honorable High Court, my lord. I intend to place it before your lordship. Thereafter, my lord, I will place. So far, my lord, to satisfy your lordship, whether, despite having, my lord, the alternative remedy, in such circumstances, the, my lord, writ petition is maintainable or not.
Yes, within those well-established exceptions.
Yes.
From Whirlpool.
Yes.
Of the Supreme Court, consistent view is.
No, so far is this act is also concerned, my lord.
Consistent view is that alternative remedy cannot be said to have taken away the power of the writ court.
Great.
But the courts have imposed self-restraint in several orders, and it is really a discretion to be exercised by the writ court to entertain or not to entertain. It appears from the impugned order that you say that perversity can be a ground.
So
you
this,
should invoke.
may I kindly appreciate.
Violation of natural justice is another ground which you should invoke. The court says that I do not find there is any element of violation of the natural justice.
So that is why
that means ultimately the court refuses to entertain the writ petition because of your efficacious remedy available in the statute.
Kindly bear for me.
This is what is the sum and substance of the judgment.
Where
so tell us that why we should enter into this. We know the exceptions. We know the exceptions.
Then, my lord, it is my onerous responsibility to bring to your lordship's notice that the honorable single bench did not consider that aspect where, my lord, it appears that it is a perverse. Kindly take, my lord, two things.
What is the purpose of arriving? What is the ingredients of arriving at the perversity?
Yes.
What are the ingredients of perversity? Tell us.
My lord, I intend to rely upon a decision.
Because when you talk about the public premises, then from I think Ashoka marketing judgment, from that you should start. Is the first constitution-based decision.
My lord, on the perversity, I intend to rely upon a decision. What principle can be, or what, my lord, the order can be said to be a perverse.
There are many.
So, my lord, for my satisfaction.
Judgment in the arbitration cases, the perversity, the Justice Nariman's judgment on a perversity, Ashoka traders or Ashoka.
So my lord, the basic principle is this. The basic principle is this. Exclusion of the relevant evidence not being considered by the, my lord, appropriate authority.
Can it be gone into in a writ jurisdiction?
Yes.
Can it be gone?
My lord, my respectful submission is yes, because coordinate bench of our High Court has categorically laid down that if the order appears to be perverse and suffers from violation of the natural justice, these are the exceptions where the writ court can interfere.
Here you were given a notice, you participated. where is a violation of the natural justice.
Yes, my lord, if your lordship, my lord,
Participated in the proceedings, whether the authorities have correctly decided or wrongly decided is a matter of appeal.
correct.
The appellate court will decide it.
But my lord, if I on the face of it, if I would be able to, I would be able to
I
satisfy
have-
your lordship
No,
that
no, sir.
that there is a my lord the document on record which fortify the fact that the my lord evidence which is in my favor that has not been considered. In that event, my lord, your lordship cannot, my lord, shut your lordship's eyes, saying that my lord, where the my lord the writ petition is not maintainable. My lord, just my lord, only for my lord for a limited purpose, I draw your lordship's attention.
We'll consider it, but
Only my lord, only for once. Then I would be my lord out of court. If I would not be in a position to satisfy your lordship, my lord.
what?
Will you kindly have a look at the document? One second, my lord.
Well, I want to.
My lord, I can read, my lord, your lordship, what is playing in your lordship's mind. There is no difficulty. I intend to impress your lordship, my lord. Our coordinate bench has categorically stated, presided by my lord Justice Sanjeev Banerjee sitting in a division bench, my lord. He categorically stated two exceptions are there. But my difficulty is this. This is the order of 27th of March 2006, which has been communicated in the year of 2023. And my lord, that has been served. It is I have already shown the document. The order has been served 6 Jawaharlal Nehru Road, not the 5 Jawaharlal Nehru Road.
This point,
My lord,
that it was served in 2023. Did you take this point before the learned single judge?
yes, I have taken paragraph 23
How
in
it
my
was
writ
dealt with?
petition.
What was the finding?
My lord, kindly see the document itself.
No. Did you raise this point before the learned single judge?
Yes,
Show us that you raised this point.
yes.
And what is the finding of the learned single judge on that?
Page 4.
Learned single judge did not consider that aspect.
Show us that you raised that point.
My lord, it appears from the writ petition itself. Kindly have a look at
Not
it.
the writ petition, from the order impugned that you have placed that point before the learned single judge.
My lord, I have.
May have taken many points in the writ petition.
My lord,
may not have
the
asked some of
principle is
those.
the, my lord, the
course of
principle is
hearing.
this. The principle is this, my lord.
We can go
Principle.
with that's the live streaming. We can go that what argument you advance before the single way, then we'll go by that.
Well, at page 4, there is also a finding.
Yes, my lord. Yes, there is no difficulty. My lord, I put down your lordship, my lord. I put down your lordship, my lord. In that event,
তারপর সোমবারে ওটা গ্রুপ 2 করে দিই।
My lord, under compilation mentioning item number 114, order for refusing to grant identity order of injunction. My lord, there is some urgency for lordship be
Yes.
item number 114, my lord.
When it is refused.
10th of November. We filed in the after that one. Now we are such a we can be disposed at any point. That's why, my lord, we have mentioned in this matter. If your lordship, my lord, it was running the list. If your lordship is kind enough to give some precedence. Item number 114, my lord.
On Monday, we'll see to it.
Lordship, the matter is very urgent, Lordship. The LLM students' admission, within 1 month, admission was confirmed, everything. All of a sudden, Lordship, with the impune notification, the admission got cancelled. Lordship, matter is very, yes.
Admission got cancelled means what?
Lordship, admission got cancelled because within 30 days, Lordship, they said that there is some shortage of attendance because AIB exam is in front.
There was a shortage.
Lordship, there was an application also given by the student. Lordship, the student is academically, if you see, 85% marks in LLB, Lordship. He gets 100 out of 199 in every subject in 10th, 12th. Very good scholar student, Lordship. This kind of, Lordship, 1 year will be lapsed. Lordship, kindly, this matter is very urgent, Lordship.
Come on Monday.
I bow down, Lordship. I will.
May I have your lordship's kindly to mention, my lord, this is running as item number 1 in today's list, specially fixed matter. But my lord, from the list, it didn't transpire that whether your lordship will be pleased to take up the specially fixed matter first or the order 41. But the issue is
The 41 we will take up, and thereafter from Monday we'll take up.
the issue is, my lord, the interim order will expire on Sunday. That's why I'm mentioning, my lord, under compelling circumstances.
What? Then it will appear on Monday. These are for extension.
May I permitted to group 2 application. Group 2 application for inclusion. It was mentioned earlier.
Item number 96.
It is my appeal. It is that matter, my lord, where there was a conflicting view taken, and surprising thing which came up that in a execution case under order 21 rule 32, they have obtained orders for selling of land, which is inconceivable as far as the civil procedure is concerned. But I bow down to your lordship's view that every decree is executable.
Not every.
Not every, but declaration, a suit for declaration and injunction. But only thing, my lord, is that without going into that, one cannot pass an order for selling properties in an
My
execution
lord,
application.
may I place the thing? May I place the?
That was that, and
Where is the decree?
my lord,
My lord, it is
they are
not there.
supposed to give all the records, and I've got the execution order.
Not the execution order. My lord, this is the decree.
Ex parte decree, my lord.
Whatever. Decree is the decree.
My lord,
It is
my lord,
suit
this is
for
not the
declaration
decree, my
and
lord.
injunction.
This is the.
1 minute.
My lord.
Declaration and injunction. তোমার কাছে নেই এক্সপার্টি ডিগ্রি অর্ডার তো নিয়ে অর্ডার 9 রুল 9 অর্ডার 9 রুল 13 পড়ে গেছে অ্যাডভান্সে এক্সপার্টি ডিগ্রি অর্ডার তোমার কাছে নেই কপি রিকলিং চেয়েছো বাবা খুব ভালো কাজ করো জন্মকে লেখা আছে এটা করলে কি করে ভাই এটা এটা তো মুখ শোনা যাবে ওকে
Execution. I wanted.
My lord, that is what I am submitting, my lord.
Give it back.
My
Where is the tenet of the decree? What is the decree which is passed?
decree which is passed, my lord. That whatever decree has been passed has been quoted by the judge in execution, my lord. Kindly see.
My lord, this is the decree, my lord.
I wanted to see the decree.
And this is the execution of quoting that it is a decree for declaration and injunction, and there is no positive direction in the decree. I am quite certain.
Dependence of permanently restrained from
আর ফরম্যাটে খুঁজে ইয়ে দেওয়া এলিও না
This was
করে হবে বল
executed under order.
কি করে পাবো
Where is a tabular statement of the execution?
but he is supposed to produce everything, my
No. I am supposed to produce, my lord, what I have produced
all right Tabular
before my lord.
that is not with us.
This is the decree which was put into execution. And in the execution, what order has been?
Yes, well, that I handed.
Well, that I have.
The execution, well, that is the order just now I handed over. Well,
The application.
this is the
The application under order 21 rule 32.
32. Well, kindly see the order directions the court is holding.
Well, this is the execution 5 of 2012.
This is the certified copy, man. তুমি আদার সাইডের উপরে ডিপেন্ড করে মামলা করবে?
কোথায় আছে বার করতে এক্সিকিউশন? এটা এক্সিকিউশনটা এইখান থেকে
হ্যাঁ,
এখান থেকে খুঁজে বার করে
That
এক্সিকিউশন।
is the detention for civil prison. Then
kindly see, well, this is the order that the court is passing to transfer properties. Well, this is the execution. That is the ordering portion. That the instant petition by decree holder, well, ordered police cell is hereby.
My lord, I have given the execution, my lord. It's execution 5 of 2012, my lord.
এটা না,
এটাই তো অর্ডারটা, এটা এক্সিকিউশন my lord, this is another copy, my lord. আমাদের কপি করা আছে দেখেছি।
এটা breach of a police helper order রয়েছে। Permission to transfer, yes. That the instant applicable file video for permission to transfer. Permission to transfer. Permitted to transfer. That execution case they were pursued. Naturally, this order has come. They were dismissed. Yes. তুমি জানো না কখন কি বেঁচেছে? 20 বছর ধরে বেঁচেছে। Don't make statements irresponsibly. দেখো তাহলে ডেটের একটা চার্ট বানিয়েছো, কোন দলিল কি নাম্বারে কোন ডেটে এক্সিকিউট হয়েছে, বানাও, দিতে পারবে না, হয়ে গেল। আসবেও না, ব্যস্ত তোমরা, কিছু বলতেও পারি না। একবার অর্ডার বেরিয়ে গেলে তারপর ডিসমিসটা হয়েছে, অর্ডার তো রয়েছে, অর্ডার পেতে তাহলে বাজে বকবক করছো কেন? এক্সিকিউশন অর্ডার হয়ে গেছে, তাই জন্য তো পার্সু করেনি, ওটা বুঝতে পারছো না? দেখো 12 সালে অর্ডার।
He is assailing.
Please. Which is the order you are assessing? This order?
No, my lord. This order, why this order was shown to your lordship was that I am assailing simply the order which did not allow my limitation application in the second round, but the same certificate, same doctor, it was allowed in this first round. The contradiction brought me to be your lordship.
To approach the trial court, I mean executing court. For what?
I'll tell you, lordship. I'll tell you. Maybe perhaps it is my fault that the facts have been too rapidly placed and there is a confusion. It is my fault.
There is no confusion in my mind.
My lord, what is happening here? What I am assailing in this appeal, my lord.
Not in appeal.
Not in appeal.
I am asking you
Here,
to
okay.
approach the executing court as a.
I never approached. They approached.
My lord, you are before the executing court. No.
No.
Then you filed an appeal before the first appellate court.
Yes.
Against which order?
Against order dismissing my application for condonation of delay in my application under order 9 rule 9.
Then you approach the court with an application under order 9 rule 9. Order 9 rule 9 is
For recalling?
applicable for restoration of what?
Order 9 rule 13.
13. So order 9 rule 13 is there, which was dismissed for default. You file an application under order 9 rule 9 with condonation application.
Allowed.
Then order 9 rule 13 restored.
Restored. When now order 9 rule 13 was getting hard, my lord, the same doctor and certificate was used because that was also filed by delay.
Order 9 rule 13 was
also delayed, and it was delayed with a condonation of delay application.
So delay was refused.
Refused.
delay of order 39, order 9 rule 13 was refused.
Refused.
Against that, you preferred an appeal.
Did not get relief. I am here.
Against that, you have come.
My lord.
So the appellate, before the appellate court, you were again delayed.
Yes, my lord. Yes. No, my lord, order.
Before the appellate court, whether you were again delayed.
No, in appellate court, I was not delayed.
Not delayed.
Not delayed.
So it was within time.
Within
Appeal
time.
was-
Appeal. But I rejected.
But the appeal is rejected.
Rejected.
That is what is the case.
That is the case. That is the case. And my lord, my case here was that once the same doctor and situation,
you did
now
not
he has come up with, my lord,
Why you did not challenge this order?
that execution, my lord, that all that by expertise, I did not know.
You did not know. Now, once you come to know,
Yes.
then what is your remedy?
Yes, I have to go to court and all that. But the question is, my lord, I went to court that kindly hear my order 9 rule 13, that whether summons was served or I was prevented by reason. That part, my lord, I was not getting chance because
Because section 5 was there.
nipped in the bud. And that is my lord, I came crying to your lordship with folded hand that at least let me try my luck in order 9 rule 13. Then he is opposing that by bringing RTI records to show, which was never shown by him in the trial court here, without making an application under order 4127, that my doctor was a quack. Lord, my case is I am ill. I have gone to a doctor with a signboard. Do I run to the medical council to see that he is a quack? He doesn't have a registration number. And today, my lord, I am being.
Yes, ma'am. My lord, and second thing,
This is
for
called
3 years, he has taken time.
Called extra biblical resurrection. My lord, to which I have become victim, my lord. I said in the first instance.
Resurrection has a limitation.
My lord, for 3 years, my lord, he took time for filing WS, and that has been considered by the appellate court
Maybe
and
I
the
am
trial court.
but my legal rights are legal rights.
My lord, it is not only section 5, my lord.
Diligent is very diligent, my lord. And insolents are fools. তুমি চুপ করো। কালকে জানলা দিয়ে চুলে ফেলে দিতে একটু
Before like your sort of effort. Where is the order of the trial court?
Order of the trial.
My lord, stay petition page, my lord.
The memo.
Memo of appeal. Order, impugned order is appearing at page
My
21.
lord, page 13 of, my lord, page 13 of the stay application is the order of the trial court.
And 21 is the impugned order, page 21.
And 17 is the impugned order, my lord, of the stay petition. Stay petition.
কি বলছো আরে টাইটেল স্যুট তারপরে অ্যাপিল ইমপিউন্ড অর্ডারটা তো 21 পেজ 21 একটু ভালো করে দেখ না বাবা উফ একই আমি কিছু জানি না তারপরে আমাকে আরো কনফিউজ করে দিচ্ছিস তুই হ্যাঁ ভালো করে দেখ 21
Where is the judgment of the trial court?
Page 17 of the 17 of the stay petition.
Steps 17 Annex B.
Call for doctor.
Where is exhibit 1?
Exhibit 1 is, my lord, at page, doctor certificate, my lord, is at page
27, my lord.
27 and 28.
My lord, 27 is the relevant one.
Relevant one, 27, all right, 27.
20.
You're right in the property.
Nothing.
The right is I have purchased by a registered deed.
Subsequently,
And
my
he
lord.
says,
Yes.
and he says, I have prior purchased the deed, the same property.
No. Both of you purchased from the same vendor.
Same. I purchased earlier at a date.
From the
Same.
vendor. Your purchase was earlier or later?
Later.
Mine was later. But then the question is, when I purchased, I did due diligence. There was no reflection. Now he comes up with a deed saying that, no, look here, I have got it much before. And that shows that that same vendor was a minor when he has ought to have sold it. My lord. And now, of course, the situation is different with regard to minor. Anyway, but that time it was anyway.
When you purchased the property, you did not get the possession?
We are in possession of the property.
No.
Demarcation is there. I got possession, everything.
The
part of it I am still in
property
possession.
described in both the deeds are one and the same.
One and the same, my lord. As far as my instruction goes, my lord. It's one and the same. That is my main problem, my lord. And he goes to the execution court, takes an order in the sly, and starts selling and creating
What
third-party
kind of
properties.
submission is this?
Rights.
Like he is
Where I the
submitting like his like.
that it execute.
How you got do you have a document that he was minor at that point of time?
Yes,
death certificate. তুমি ডেথ সার্টিফিকেট মাইনর
97
হ্যাঁ
Give the birth certificate, not the death certificate.
that is what my learned friend is showing. I've got a great advocate on record, I've got great advocate, but I am responsible for it. When this is the document by which he is purporting that he is
Not purporting. Tell me that
that Murtaza Ali
that he was minor.
minor.
What is the document which you have?
He that is the my
37 years old.
এটা কার তুমি দেখাই গোলাম মুর্তজা a certificate of death. He died.
Died.
Oh, why my learned friend is showing the death certificate? That this is a death certificate dated 14/10/97 when he was declared to be 37 years of age. Therefore, that the deed, if my lord sees, is then he was minor because the death certificate records his age. That is why it may be relevant. That Ghulam Murtaza, from whom he has purchased, I have purchased, he died on 14/10/97, and death certificate says he was a male aged 37. So, my lord, 97 and one goes 37 years back, and the date appearing in his purchase deed shows that he is a minor. Ghulam Murtaza.
I have purchased in 76.
76, he was a minor. And when he became major, consciously, he sold, gave me possession, it continued, village, everybody knows everybody. And then all of a sudden, my lord, he comes and starts selling properties, taking an order which is completely.
Have you challenged the order, my lord, till date?
I might not have.
You might
But
not have.
illegality, fraud cannot be, frontiers of fraud
My
cannot
lord,
be.
it's a death certificate, what they are showing.
It cannot be extended.
The second miscellaneous appeal.
Yes, my lord.
Stricto sensu, you have no right of audience as of now. Yet we are giving you some opportunity that's there. But technically, you have no right of audience.
My lord, I understand that, but
That, then keep mum.
But
What you have done is very apparent.
no, my lord, I purchased from a person, my lord. I am not
Sorry,
supposed.
this executing court, why you invited this, I would say, the just a junior judge to pass such an order?
My lord, may I, my lord?
May I?
My lord, may I, my lord?
What
My
was
lord,
the nature of the decree?
my lord, nature of the decree is recovered.
That your right, title and interest in respect of a property was declared.
Yes, my lord.
Second part of the decree was that he was restrained from creating any obstruction
My lord.
in your possession.
My lord,
You filed an execution case alleging that he is obstructing your.
because he was filing another, because he was filing other suits, my lord.
Restrict to your case.
My lord.
Your execution originated on an allegation that he is interfering with your possession despite the permanent injunction having granted against him. In this execution case,
Yes, my lord.
application seeking permission to sell the property
Yes, my lord.
is filed and the executing court is allowing that application.
My lord, because he,
What authority?
my lord, because he has filed another suit on the self-same ground, my lord. My lord, that suit, my lord, he never appeared. That subsequently become, my lord, they have not appeared, my lord.
I'm asking you, what is the power of the executing court if the nature of the decree is such? Is it a money decree?
No.
Was there any sale or the auction?
No,
conducted?
no.
Then
But they were they kept
Sorry,
on, my lord.
you
My
have
lord,
to approach a court, the court must exercise jurisdiction within its power. It cannot go beyond the jurisdiction.
No.
That whatever is there under the earth, everything will be given. What are you talking about?
My lord,
You have invited. It must be she has just joined. And you have invited this order.
my lord, that is, my lord.
That is what?
My lord, judge, my lord,
Different thing.
my lord, learned judge, my lord, knows her duty, my lord. My lord, must.
So you can say many